Something fundamental has just shifted in American gun law, and if you're relying on mainstream news outlets, you might not get the full picture for weeks. But right now, today, we're going to break down exactly what happened, what it means for your daily life, and how you need to think about it. There's a version of this story circulating that overstates things, and another that understates them. And neither one is useful. So let's start with what we actually know. The Supreme Court has acted on the issue of firearm carry permits, and the signals coming out of that courtroom suggest we're at the edge of a constitutional reset that most gun owners are completely unprepared for. An emergency application reached the court arguing that permit requirements in certain states have become so burdensome that they actively prevent law-abiding citizens from exercising a constitutional right in real time. The court agreed to hear it, and when justices accept a case on an emergency basis, that decision alone sends a message that legal analysts are still processing. The Supreme Court doesn't move quickly unless it believes something serious is happening right now. Emergency designations are rare. They signal that the justices looked at the situation and concluded real people are being harmed by an unconstitutional system today, not years from now, and that it cannot wait for the normal timeline. But before we dive deeper into what the court actually said and why it matters, we need to go back to the beginning. To understand why this case is so significant, you have to know where permit systems came from. For the first century and a half of American history, there were no permits required to carry a firearm. Ordinary people carried guns as part of daily life. There was no government office to call, no application to fill out, and no official deciding whether your reason for self-protection was good enough. That simply wasn't how the country worked. The idea that a law-abiding citizen needed the government's blessing to exercise a constitutional right did not exist until the early 1900s. The history of how it changed is something most people have never been taught. Many of the earliest permit laws weren't about public safety. They were designed to keep firearms out of the hands of specific groups, primarily Black Americans and newly arrived immigrants. The Second Amendment existed on paper, but powerful people found ways to make sure it only worked in practice for certain individuals. The permit system became a filter, and that filter was never neutral. It was built to exclude, and that design philosophy got baked into the foundation of permit law from the very start. As decades passed, permit systems grew and multiplied. Some states kept the process relatively manageable, while others turned it into an obstacle course rather than a legal procedure. By the time this current challenge was assembled, applicants in certain states faced hundreds of dollars in fees, mandatory training classes that cost even more, months of waiting, extensive background investigations beyond federal requirements, and still encountered denials that made no logical sense. And I want you to picture what that looks like on the ground, because this is where the bureaucratic reality becomes nearly impossible to defend. One applicant was denied simply because the official reviewing his application decided his handwriting was too disorganized. Another was turned down because she had posted a photo of herself at a shooting range, which the permit office interpreted as excessive enthusiasm for firearms. Think about that for a moment. A legal photo at a shooting range used as grounds to deny a constitutional right. The system had gone so far off track that it no longer screened out dangerous people. It was screening out anyone who couldn't afford attorneys, couldn't handle 12 months of bureaucratic uncertainty, and couldn't navigate a process quietly designed to be as difficult as possible. Gun rights organizations had been challenging these systems in court for years, winning some battles and losing others. Then a coalition of Second Amendment groups decided to stop playing small. They built a case around a simple, direct constitutional argument. The right to keep and bear arms shall not be infringed. That's what it says. Not shall not be infringed unless the state creates a complicated application process. Not shall not be infringed except when a government official decides you haven't proven your need. It says shall not be infringed. Requiring a law-abiding person to ask the government for permission before exercising that right is infringement by definition. And they back this with a pointed observation: no other right in the Bill of Rights works this way. You don't apply for a free speech permit You don't wait months for approval to practice your religion. You don't submit a request before publishing an opinion or attending church. The Second Amendment had been carved out and treated like a conditional privilege, while every other fundamental right was automatically yours. That inconsistency became the core of the challenge. Now let's talk about what happened when this case actually reached the justices, because this is where the story takes a turn even seasoned legal analysts didn't fully expect. The Department of Justice, the same agency that historically fought these kinds of challenges aggressively, walked into the courtroom and sided with gun owners. Let that sink in for a moment. The federal government reviewed permit systems nationwide, drew on data, and concluded that these systems had crossed a constitutional line. Specifically, the DOJ argued that permit requirements have become so financially and procedurally burdensome that they effectively block working-class Americans from accessing the Second Amendment. That position carries a different weight than any private legal organization could submit. The justices understand that the DOJ has resources, data access, and institutional knowledge most parties lack. When the federal government tells the Supreme Court that permit systems aren't producing safety outcomes that justify restricting a constitutional right, that's not a statement the court can easily ignore. Then came the detail that made even experienced attorneys pause. Several states with their own permit systems filed briefs, not defending them, but asking the Supreme Court to strike them down. In effect, these states said, "Please eliminate the permit laws we created." Their reasoning was candid. They admitted their permit frameworks had become so complex and inconsistent that even their own law enforcement agencies struggled to administer them correctly. They also acknowledged something gun owners have been saying for years. Traveling across state lines with a legally owned firearm has become a legal minefield. You can be carrying lawfully in your home state, cross a border, and suddenly be violating completely different rules without changing your behavior. A right that can make you a criminal 40 miles away is not functioning like a right. It's a patchwork of traps. Think about what that means for real people. Truck drivers, traveling nurses, anyone visiting family across state lines, they live this reality. They memorize different rules, carry paperwork, and constantly second-guess whether they're compliant. That is not freedom. That's administrative anxiety disguised as regulation. Inside the courtroom during oral arguments, the skepticism from multiple justices was sharp and pointed. When a justice asks whether the Constitution or the historical record ever mentions needing prior government approval to exercise this right, that's not idle curiosity. That's a signal. The argument has a serious problem. Lawyers defending permit systems tried several strategies. First, they argued states need room to regulate firearms based on their communities. A densely populated city has different dynamics than a rural county. Sounds reasonable, but it runs straight into a wall when applied to constitutional rights. Your right to a fair trial doesn't shrink in a city. Your protection against unreasonable searches doesn't lessen with population density. Constitutional rights aren't adjustable based on geography or demographics. The justices understood that. Second, defenders warned of consequences. Eliminating permit requirements would lead to a rise in gun violence. More guns in circulation without screening would create chaos. It sounds alarming, but alarming predictions must eventually be backed by evidence. When the justices asked for data from states that had already moved to permitless carry, the defenders struggled. They cited opinion pieces, advocacy reports, and projections based on assumptions. Meanwhile, the challengers presented real numbers from real states, showing no catastrophic outcomes after removing permits. That contrast hit hard. One moment became a flashpoint. A justice posed what amounted to a logic test. If permit requirements genuinely aim to keep dangerous people from carrying guns, why do only law-abiding citizens comply? Criminals don't fill out forms or wait months for approval. They ignore the law entirely. The only people affected are those already following the rules. A permit system, in practice, only blocks law-abiding citizens while doing nothing to stop actual threats. There was no clean answer to that, because there isn't one. Now let's be precise about what a ruling against permits would actually change, and equally important, what it would not change. Like, if the court rules that permit requirements are unconstitutional, the most immediate change is clear. Any law-abiding citizen legally allowed to own a firearm could carry it for self-defense without first obtaining government permission. Well, no fees, no months-long waiting periods, no applications reviewed by an official with broad discretion to say no. The barrier between a law-abiding citizen and the practical exercise of their right is removed. For states with the most restrictive systems, where the permit process is deliberately difficult, expensive, and often requires connections or attorneys, this would be a major shift. It would restore carry rights to ordinary working people. But here's what does not change, and this matters. You still must be legally eligible to own a firearm. The federal background check system remains in place. Convicted felons, those with domestic violence convictions, individuals involuntarily committed to mental health facilities, or anyone on the federal prohibited persons list still cannot own firearms. Every gun purchased through a licensed dealer continues to go through that check. The only change is the removal of the additional state-level permit layer on top of the federal system. Prohibited locations, schools, courthouses, government buildings, airports, and other sensitive areas remain off limits. Private property owners and businesses can still restrict firearms. What shifts is that law-abiding citizens no longer need prior approval to exercise a right. The Constitution says shall not be infringed. The scope of this case is specifically and narrowly about the permit itself. Let's be real about what comes next. If the ruling goes as evidence suggests, it won't close the book on this fight. It will open new chapters. Some states will almost certainly try alternative frameworks to achieve the same practical effect using different legal language. Mandatory training, certification requirements, registration systems, fees rebranded as administrative costs. Gun rights organizations are already mapping out these workarounds and preparing to challenge each one immediately. A ruling would be a major constitutional victory, but it would also signal the start of the next phase, not the end. In the meantime, practical advice is simple. If you're in a state that currently requires a permit and want to carry, go through the existing process. No pending court decision protects you from laws still on the books. Pay the fees, do the paperwork, and cover yourself until the legal landscape officially shifts. It's frustrating and expensive, but getting arrested for a permit violation because you assumed the Supreme Court would fix, it is a risk nobody wants. Document everything: applications, receipts, training certificates. If the legal landscape shifts, that paper trail could matter. Whatever the court decides, responsible gun ownership foundations don't change. Get proper training, practice regularly, know your state's self-defense laws in detail, understand escalation and de-escalation, store firearms safely, and respect prohibited locations. These aren't government-imposed requirements. They are what it looks like to take a constitutional right seriously. Preparation isn't fear, it's freedom. And freedom requires competence. This case fits into a broader shift the court has been making. The justices increasingly reject interest balancing, which asked whether a gun regulation served an important public interest and whether the burden was proportionate. The current majority applies a different standard. They look at the text of the Second Amendment and historical traditions at the founding. Regulations survive only if consistent with how Americans historically understood the right to bear arms. Broad, discretionary permit systems, with subjective approval criteria, months-long waits, and high fees, have no historical analog. Combine that with a federal government siding with gun owners and states voluntarily asking to dismantle their own permit systems, and you have a convergence that is rare. The constitutional conversation around carry rights may look fundamentally different after this ruling. People who understand what changed, what did not, and what responsibilities come with it will be far better positioned than those reacting only to headlines. Here's what I want to know from you directly. If permit requirements disappear in your state, does that change how you approach carrying? Were you waiting for exactly this moment, held back by cost, delay, or discouraging processes? Or have you already been through it? And this mostly removes paperwork. Do you believe this outcome makes the country safer or introduces risks courts underestimated? Smart, informed people land on different sides. Drop your perspective in the comments. Tell me your state and how this lands from where you sit. Real experiences paint a picture no legal brief ever fully captures. Stay informed as this develops. When the ruling drops, go deeper than the headline. Read what the justices actually wrote. Understand the reasoning, not just the outcome, because reasoning shows where the next battles will be fought. And there will be next battles. The constitutional debate over the Second Amendment is not ending, it is accelerating. 2. People who stay ahead will always be better prepared than those reacting to noise. Stay responsible. Stay informed. Rules of gun ownership in this country are moving fast. Understanding exactly what is changing and what is not is what separates clarity from confusion.